case?
Well, I was just about to take your lordships to King. That's in the Joint Authorities bundle at tab 4, page 51. My lords, the background to this case is set out in the head note. The appellant King was an erstwhile employee of the respondent weather service, or I think its former incarnation, it's referred to as the Bureau, South African Weather Bureau. And while in their employment, he'd written several computer programs which were designed to conform with and eventually became an integral part of the Bureau's system. And in the head note at 4, your lordships see about halfway down the summary, the appellant said that he'd initiated the program development after hours at home, although with the passage of time it was clear that he spent increasingly more of his office hours developing programs, and refers to a job evaluation where he was spending more of his time doing that. If I can pick it up then again at paragraph 4 of the judgment, which is on page 54 of the bundle, the final paragraph on that page. So the court summarises the King's case in the court below, and he said that he'd created a number of weather programmes. Again, they'd been written in his own time at home to assist him personally in the performance of his duties as employee. It hadn't been part of his duties as a meteorologist to write computer programmes, and that he'd authorised the respondent by means of a tacit licence to use the programmes which he'd withdrawn from June 2002. And I think, my lords, I can probably then skip on to paragraph 18 of the judgment on page 58, which is where the Court of Appeal consider the course of employment question on the fact. And, my lords, the first point I wanted to pick up on paragraph 18 is that the court notes that the programmes were directed directly related to the business of the Bureau. They captured, rectified and transmitted weather data to head office, and as Mr. King reluctantly had to concede, the programmes were to the advantage of his employer. They were written to conform with, as I noted from the head note, and incorporated, became a part of the Bureau's existing system. So it's right to note that we're not dealing with an existing system, i.e. one that was extant at the time when Mr. Penhallurick began his employment here. But we are on, dealing with certainly a tool, now the VFC methodology, which was being used extensively in MD5's business. And then at 19, the court notes that although Mr. King's duties as a meteorologist wouldn't normally embrace software development, they note that it was significant. That's not the full picture. And they note that Mr. King had developed his programmes for the purpose of assisting with his duties of collecting and collating meteorological data and transmitting it to head office. He may have done it to make his own job easier, but he did it, they say, because of his employment with the Bureau. And then at 20, they develop that point and note that it was King's employment with the Bureau that was the ultimate cause. I think the cause of causans is the Latin that they use of his writing the software. And so, my lords, I accept, if one is drawing parallels with this case, that if one's proceeding on the premise that Mr. Penhallurick wrote some software before being prompted to do so by Mr. Boyd or Mr. Green, and it's not such a clear-cut situation here. But having said that, as I've explained, the VFC methodology was a tool being used. The whole point of it, of the software, was to automate that tool, make it faster, make it more easy, both for Mr. Penhallurick's benefit and for those of his colleagues. And as I took your lordships to, he'd witnessed, or his evidence was that he'd witnessed the difficulties of his colleagues in using his method. And we do know that apart from the September, whatever work that he says he did, he then only came back to, as we've discussed, is what he called his first attempt at the automated methodology after he was being employed and at a time when the methodology was being used extensively. My submission that the two cases aren't very far apart in that sense. In both cases, it's work being instigated by the employee, which will assist in their performance of their duties and would benefit their employer. Just two final points at 21. Just to note, they refer to Mr. King's reports about the performance of his duties that stressed the major component of his work was programming. And then at 22, back to that point, that although it must be accepted that his initial programming took place at home, it is clear that as time passed, he spent increasingly more of his office hours developing such programs, to an extent that he failed to give sufficient attention to his duties as head office, at the head office of Uppington. So that's King, my lords, and it is a different case and with different facts, but the factors on which the Court of Appeal, South African Court of Appeal, placed weight on here align in my submission with what the judge placed weight on in this case as regards the existence of the methodology and how it was being used by MD5 at the time. The software was an enhancement to that methodology, and clearly that would be something MD5 would want to use. And in fact, my lords, just further on this point, Mr. Penhallurick does appear to have accepted that in relation to other software that he said that he'd developed during the course of his employment. And my lords, this was a point that he mentioned for the first time in cross-examination. If I could just show your lordships the cross-examination on that. It's in the supplementary bundle, tab 31, page 492.
Give me the page number again, please, Mr. Conway.
Page 492, although it will go over to the following page. And if your lordships pick it up around about, the question around about E in the margin, I'm asking him here about his January appraisal that we've looked at. I'm looking at the paragraph in the same box. In fact, well, if it's possible, perhaps just so your lordships can see what this cross-examination is about, I don't know if it's possible to also have open that annual appraisal at page 118 of the supplementary bundle, tab 7.
218?
118, sorry. I just wanted to show your lordships that, so your lordships know the passage I'm referring to. It's in this first box, and it's the paragraph just below the one that the judge quoted, where Mr. Penhallurick says, "Throughout the year, I feel I've managed to undertake a reasonable amount of forensic work, as well as machine and network maintenance, software development, and other ad hoc tasks." And in fact, my lords, the fact that he's just referring to these under that penumbra of ad hoc tasks that he just notes as in his analysis of his performance of his duties is relevant to the point about this being outside the scope of his employment in itself. But that's so your lordships have seen it, and around about E, I'm taking him to that paragraph, and I note the words that I've just quoted to your lordships. And I make the presumption that software development is a reference to VFC. And he says, no. Oh, so that was other software you were working on then? And he explains, yes, software development. And so my question then is, was software development generally, that was part of your role at VFC? And if your lordships could just read his answer then that follows over to just about B on the following page. So my lords, he describes it as not part and parcel of his day job, but evidently his evidence here is that he developed various software tools that he describes as being to alternate. I think that must be from the context automate tasks that others would do manually, and he says he'd work out how to do that and share it with his colleagues. And he developed a number of such tools that I did at MD5 and left them, automating any number of different routines. And there's no suggestion here that he was doing this under the specific direction of his managers. And just below that passage, I put to him that he's describing this in terms of how he performed his role at MD5 generally, and he makes the point. Well, I think that the context is different. The software developing was the scripting, which he says was a subset of a forensic tool. But was, of course, VFC was itself a forensic tool. And so I suppose it's quite hard to see where Mr. Penhallurick makes the distinction between work that he undertook on his own account to automate existing forensic tools without prompting by his employers, but that he saw, it would seem, at least in this regard, as part of his duties or ordinary scope of his employment. And we say that bears out the judge's findings at paragraph 67. And finally, on that point, models, we say the judge's conclusion at paragraph 67 was also supported by his findings of fact at 54, that Mr. Green and Mr. Boyd discussed creating a software version of the VFC methodology. And my learned friend criticises the judge's finding about the date of that conversation that was likely to have happened in December. I think it's fair to say the evidence was not entirely clear on that, and in some fairness to the judge, he referred at paragraph 49 to the fact that it was submitted to him by Mr. Penhallurick's counsel, that in relation to Mr. Green's evidence, it was more likely that Mr. Green would have seen a demonstration in November. And so that was a submission that was made to him by Mr. Penhallurick's counsel as well.
But that's relating to the demonstration, not the discussion.
No,
and I appreciate that it was Mr. Green's evidence that the two things were coincident, but nevertheless they are conceptually distinct.
They are, and that appears to be the basis for the judge's reasoning. But
could you just try and unpick for me the chronology that the judge is contemplating in paragraph 67? Speaking entirely for myself, I find it somewhat difficult to work out what happened. We've got various events. We've got the permission by MD5 to devote all or the bulk of his time to writing software. Then we've got the demonstration, and then we've got showing the manual, VFC. I don't know whether that's the same thing. And then there's the discussion. It's referred to towards the end of the paragraph. And then he says work done by Mr. Penhallurick on VFC software at the end of December would have been work which he understood to be integral to his duties. I just find it very difficult to work out what the order of events is out of all that.
Well, my lord, trying to piece it together, I think permission by MD5 to devote all of the bulk of his time to writing it. Certainly that was, I think the consensus position would be from January, mid-January onwards. That was the evidence of both Mr. Boyd and Mr. Green in evidence in chief. Right. And it was Mr. Penhallurick. The dispute there, of course, is who brought the idea to whom, but the timing would be.
So the permission is January.
Yes.
And so Mr. Penhallurick wrote a small part of it before January.
Yes.
And he did it at home and so on.
Yes. And
By then he demonstrated. So the demonstration you think is the judge is contemplating early on.
Yes, and certainly that was Mr. Boyd's evidence. I think Mr. Penhallurick's evidence that was early after he started.
Yeah, November.
Likely around November.
And then when's the discussion?
And the discussion on Mr. Boyd's evidence certainly was January. I think the same is true of Mr. Green's evidence in chief.
Hold on, Mr. Kelly. Yeah.
The same is true of Mr. Green's evidence in chief.
Yeah.
I suppose the only caveat to that is Mr. Green's evidence in cross-examination, which is where he said, actually, I'm not sure.
But I thought you told us before the short adjournment that you accepted the judge's finding that the meeting, which must be the same thing as the discussion, was in December.
Well, my lord, I don't.
You either do it or you don't accept it. There's no middle course, Mr. Conway.
Right. I think our position has to be that our evidence was going into the trial that it was January, and the judge appears to have what the judge has done is taken Mr. Green's evidence in cross-examination, and perhaps combined with the point that was put to him, it would seem in closing by Mr. Penhallurick's counsel, which he refers to at 49 of the judgment, that it took place earlier, and he's taken that as the basis for determining that it was likely. I mean, in fairness to the judge, it only says it was likely. He doesn't make a sort of.
That's what we call the balance of probability.
Yes.
So,
yes.
The judge says discussion November, end of December.
Yeah.
But where does that leave? Where does that leave the work that was done? Was it after the meeting or before it? This is what I find very difficult.
Paragraph 54 also has some bearing on that as well.
Yeah. Yeah. So that would be consistent with the discussion happening in January, but acknowledgement that some work had been done prior to that in December.
If you put 54 and 67 together, the judge is saying he started in late December and the discussion took place at the end of December, so that no work was done in the course of December.
Yes, I think that would be the findings made in both of these paragraphs. Our evidence at trial was that a discussion took place in January. I think that was, leaving aside, who brought it to whom, that was Mr. Penhallurick's evidence as well.
Was the judge entitled to find that it was the discussion was at the end of December?
Well, my lords, the only basis I think that he had to make that finding would have been Mr. Green's evidence in cross-examination. So that was, I mean, it was a factor that he obviously placed weight on that.
Was Mr. Green's evidence as specific as end of December?
No, I think it's fair to say, my lady, it was along the lines that I think he said he wasn't entirely sure,
He said November, possibly December. I think is what he.
Yes,
actually
I think
said.
that's.
He said
I mean,
November.
it may be. I should probably.
My
take the
recollection is that he seemed to be saying that he had this discussion with Mr. Boyd about when it was, at the time that he was preparing his witness statement, and not to then stop January in his witness statement, which is not very attractive.
Perhaps not model, but yes, I think. I mean, would it be helpful to just turn that cross-examination out? So we're not. I don't really want to be making a submission about what he said without documents. So it's tab 31 with the supplementary bundle. And actually, it's probably worth picking us up on page 532, which is a little bit before the passage that your lordship's seen. And so, just at the top, Mr. Green's being asked about his evidence. I think this is in Mr. Green's first witness statement in paragraph 5, where he doesn't give dates, but he says that he was asked if he'd like to see a demonstration of Mr. Penhallurick launching a desktop forensically, and then it's put to him that the timing of it, the way he's worded, fits better with Mr. Penhallurick's evidence that he showed the manual method in around November. Is that right? I would think so, yes. I'm not certain about the date, but it was after he joined the company. And then there's some more cross-examination, and I think just to show it where it continues at the top of page 533, the point there is made to him that he doesn't give dates for any of those events that we looked at. And he says, no, I'll just give a true and accurate statement. And then he gives what is, I think, fairly characterised as quite a long answer. Going over
That's
the next
statement.
Going over the next 2 pages. And then it's on page 535 that we come back then to what is put to him about his paragraph 5 now in his second witness statement, where he does state that he saw the step-by-step methodology in January 2007. And the point's put, it was like, well, earlier you said it was likely to be November. And at that point we said, well, I wasn't exactly sure about the dates. So, I know he started in November, may have crept into December, not sure. And then towards the bottom of the page, was it November or January? I think it was more likely November or early December. So,
but I don't understand this, Mr. Conroy, because this is all about when was the methodology shown to Mr. Green. And it doesn't appear to be in any real dispute that methodology was demonstrated soon after Mr. Penhallurick was employed, which we know was 6th of November. The question of when there was a discussion about writing software is a different one.
yes, I think, my lord, to shed some light on it, it's right that Mr. Boyd and certainly Mr. Penhallurick said that it was demonstrated much earlier on, but I think Mr. Green's evidence in chief was that he only saw the manual methodology in January 2007. And just to show you that, that's Mr. Green's second witness statement, which is what he's being asked about here.
Sorry, so are you saying that Mr. Green's evidence was that there was really only one occasion as far as he was concerned?
I think he says there was only one occasion where he saw it, which is what he says here.
But the more relevant point is whether he was saying that was the same occasion on which this discussion occurred.
Well, I think that is the premise, my lady, on which that the start of that passage of cross-examination is put. Yes. But his evidence doesn't say that. His evidence is simply that, just to show the lordships, I'm conscious on time, but just
sorry, just before we go to that, can we just finish off with the cross-examination? Because at crossing 535 to 536, there's the answer at G. He only demonstrated once when I was present. That was to me and to Mr. Boyd. And we have Boyd's evidence that that's January. And then he's asked at H, well, which of the dates is it? Is it November or is it January? And the answer comes back, think more like November, might have been early December, rather than January. And that fits with Mr. Penhallurick's evidence in terms of the demonstration, doesn't fit so far as a discussion is concerned.
No, and I think the discrepancy arises in that Mr. Green's evidence in chief was that he had only seen a demonstration in January. Mr. Boyd had, of course, seen it much earlier, and indeed was using it. But Mr. Green saw a demonstration, he says, of the methodology in January, and it was after that he had a conversation. And that's in paragraph 5 of Mr. Green's second witness statement.
So the conclusion might be, I mean, you can tell me if this is your submission in the moment, but a possible conclusion is that at this point in his cross-examination, he's got confused as to the chronology, and that actually the correct version was what he put in the witness statement.
And I think, my lords, that's probably the best way of reading his evidence, because he is unsure about the time here, and it would be more consistent with the evidence, obviously, that he gave in chief and that of Mr. Boyd, that he saw a demonstration. He saw a demonstration in January, although of course it was already in use.
Okay, so can we quickly look at the witness statement you were going to go to?
Yes, that's in Supplementary Bundle tab 14, page 228. And it's paragraph 5.
See, I'm grateful that you took us back to this, because Mr. Caddick had shown us this earlier, but I've forgotten exactly what had been said here. So in terms of the timing of the demonstration, we've covered that already. But then the other question I just wanted to ask you, is, having been refreshed as to my memory of what he said, is that on Mr. Green's evidence, he's shown the methodology in January. He then speaks to Mr. Boyd privately, in other words, Mr. Penhallurick not present. On his account, it's Boyd alone who has the discussion with Penhallurick about software, and Boyd comes back to Green saying Mr. Penhallurick can do it.
And I think that's Mr. Boyd's evidence in chief was consistent with that. Reference for that. Sorry, I don't. Obviously, conscious to bottom this point out. Mr. Boyd 2, paragraph 10, on page 238 of the same bundle that we're in.
Okay, thank you.
As I understand it, you say you can support the judge's conclusion even if this discussion had not taken place in December and took place in January.
Yes.
On the King basis.
On the King, precisely. Yeah. We say
it was a tool for doing the work that was.
And he was well aware of that.
Yeah, I mean, the distinction, that I'm grateful for the reference for Boyd 210, page 238, because there the difference in the chronology, or in the two events, I'm sorry, is very clear, as he talks about the demonstration of the methodology in November, and then the January demonstration to Mr. Green, the discussion between the two of them, and his Mr. Boyd's then discussion with Mr. Penhallurick about the possibility of developing software.
Yeah.
And that's why, it comes back to me now, this is why Mr. Cuddick was focusing upon this chronological question in his submissions to us in opening the appeal yesterday morning, because he said, what Mr. Cuddick submitted was to say, well, let's assume Messrs. Boyd and Green are correct at least as regards the chronology of the demonstrations. In other words, there was one to Boyd at the outset in November, and then one to Green in January 2007. How does that square, says Mr. Cuddick, with the evidence that there was work done on the software in December, and indeed more than that in September? So that's his submissions to the relevance of that chronology.
Yeah, yeah. And we say that, as my Lord Sir Christopher Floyd put it, that even if the work done, it would be consistent with the judge's approach at 67, that even if Mr. Penhallurick had done work in December before that conversation had taken place, nonetheless that still would have been work done in the course of his employment. And I do say that whatever the date of the discussion that took place between Mr. Boyd and Mr. Green, the very fact that they saw themselves the utility of automating this as a tool, saw that could be done, and indeed, on Mr. Boyd's evidence, discussed between themselves the idea of hiring a third party to do it before having the conversation with Mr. Penhallurick, shows that this was clearly something that MD5 would benefit from, and that's just consistent with it automating a useful tool that it was already employing and marketing. The further point relied on by the judge relates to to the scope of Mr. Penhallurick's employment. The judge dealt with this, and specifically in relation to Mr. Penhallurick's contract of employment at 60 to 62 of his judgment, and that's Core Tab 8, page 89, where he sets out a passage from the employment contract. At 61, the judge placed particular weight on the fact that clause 15 related to intellectual property rights, and implies, the judge said that it was contemplated that Mr. Penhallurick might write copyright works, and in the context, he found that was likely to be software. And my learned friend says, and rightly, that there's no express reference in this contract of employment to VFC or software development per se, and to that, of course, say that the precise terms of the contract aren't determinative. It's quite possible for the scope of an employee's duty to evolve without them being explicitly recorded in writing, and we say it's apparent that happened in this case. And Mr. Penhallurick's appraisals, which the judge also referred to in his judgment at paragraph 66 and elsewhere, the content of those appraisals are particularly instructive on that point, and that's because the point that I just noted to your lordship in going to that appraisal, the way Mr. Penhallurick described doing ad hoc tasks, including software development and also other things like network maintenance that he mentions, that again wasn't expressly part of his contract of employment. So there's no sense that he sees it as inconsistent with his overall scope of employment, that he might be assigned these tasks that are out with the sort of core role of forensic analyst. He doesn't sort of raise any suggestion that was something untoward or unusual in relation to network maintenance or software development generally. And indeed, as we saw, he was talking about different software development in that case. So we say that the judge is finding that software development per se was within the scope of Mr. Penhallurick's employment, was again supported by the evidence. So, my lords, just to pick up on a few of the criticisms of some of the criticisms of the judgment my learned friend makes that I may not have covered yet. I think I've dealt with the point about the first work and the judge's approach wrongly being predicated on the non-existence of that. We've been over that ground. I should pick up on my learned friend's point that Mr. Penhallurick's evidence was that he'd been advised while he was at Cranfield that if he wrote software during the course of his employment, it would belong to his employer, or at least in the context of the university. And we say that, I mean, it's little more than a possible factor that the judge may have taken into account. The judge certainly referred to it at paragraph 47 of his judgment, so he was aware, of course, that that was Mr. Penhallurick's evidence. But beyond that, my submission, the point doesn't really go anywhere. For a start, if it was the case that the reason Mr. Penhallurick hadn't written software at an earlier point was that he was concerned about the employee position, well, there was no good reason why he'd not done anything in the nearly a year between leaving Cranfield in 2005 and the earliest point, September 2006, when he was a free agent. And indeed, if it was the case that he had already written software at the point when he started at MD5, even if he had just made a start, why did he not make that position clear to his employers at the time when he was demonstrating his manual method? Because if he had concerns about work that he might then do on the software, potentially belonging to his employers, if he was aware of that, and of course he was aware of the contractual duty, which your lordship put it, I think, just essentially apes the statute, but nonetheless that was in his contract. So why did he not mention that he already had this software that he'd come up with, and that was an idea he was working on? That would have been the logical way to protect his rights. The further, I think I've dealt with the copyright notices that my learned friend mentions, and the date of the conversation that happened as well. Further point that my learned friend relies on is what he characterises as the parties instead working for mutual benefit. And I think my learned friend's point here is really that this distinction between work done on the core functionality of VFC rather than the security aspects or securing for sale. And the first thing to address here is exactly what Mr. Penhallurick was referring to when he talked about security features. And probably the best place to go to for that is in his cross-examination at paragraph 31, page 508. In response to a question put by the judge. So just the question just above B in the margin, the judge asked, just so I have it straight, can you run past me the precise distinction? Sorry, page 508. And so his answer is, well, it was the security aspect, the code I developed to make sure it was secure. People couldn't circumvent that. They had to have a licensed dongle that expired after a set period of time. And he goes on to explain how that worked. And then it's asked, are you saying the security aspect of the software was owned by MD5? Yes. How would you describe the rest? And then he talks about the core functionality of virtualizing the machine is the core from VFC version 1 and every version onwards. And then he also mentions the password bypass method that he came up with because and then he goes on to explain what that was and that he did a lot of research on that in his own time. So I think that is appears to be part of the core method, or at least the rest, i.e. being not being owned by MD5. So that's just so your Lordship can see it, because I think that's probably the clearest exposition of what Mr. Penhallurick had meant by this distinction. The judge dealt with this point at paragraphs 90 to 91 of the judgment, and that's in the core bundle tab 8, paragraph 95. So this is in the context of the November agreement. But your Lordship, see it at 90, this is the point I mentioned earlier. He says, Mr. Penhallurick, the finding was that he devoted most of his time from January to February. Mr. Penhallurick dealt with this in cross-examination by explaining the core functionality had been created at his own time. I think it's unlikely that he created none of the core functionality during his work hours devoted to VFC software and at work. And then at 91, he records that no reason given why there was any commercial logic in MD5 owning the copyright security source. And that's relevant to construction of the assignment, so I'll come back to that. But then he goes on to say that there was no indication of anywhere in the documents of such a split. That was right. There was no hint in any of the contemporary documents that such a distinction was in the minds of either Mr. Penhallurick or MD5. I showed your Lordships his appraisal. There's no reference or suggestion by him or Mr. Boyd, indeed, that there was any, when he talks about VFC development, that there's any distinction, and he's focusing on, in particular, on security licensing when he's assessing his performance by reference to that development work. And there was no hint of it in any of his later appraisals, where he continues to refer to his VFC software development work. And I went through all of those documents with Mr. Penhallurick, and he acknowledged that at least there was no reference to that. I won't go to it now, but just so your Lordships have the reference to the cross-examination on that. It's in Supplementary Bundle tab 31, page 494, and then the other reference is again at 499 from around C to H. So that's just why I took him through the appraisals. It was also Mr. Penhallurick's evidence that he would work on core functionality at home and test it in work. And that's something actually that he refers to in the passage quoted at paragraph 63 of the judgment. Your Lordship has seen that. But that very process of testing and then further development was something that he agreed was an important part of the software development process. And I've given references to that in my skeleton. The transcript references for your note is tab 31, pages 482 to 483. And also just a note on that was consistent with Mr. Clark's evidence. He also said that it was artificial to distinguish between testing and development. He said they were both part of an iterative process that he called software development, pure and simple. That's Clark 2, paragraphs 118 through to 124, and it's Supplementary Bundle tab 24, page 336. And one can see that that's a logical approach to the way software is developed iteratively in that way. It's also notable on this that his evidence to the judge that we just saw referred to the password bypass routine as another aspect of VFC functionality that was outside of what MD5 owned. That was a later development that was added to VFC2, and again that was something he specifically mentioned in his appraisals as having spent a lot of time working on. And I can just show your lordships where I put that to him in cross-examination. It was back in the bundle, tab 31, page 509, that's that long bundle.
Sorry, did you have a page number?
509, my lady, sorry. So just around about E, this is following the passage, the interchange with the judge that your lordships just saw, and I just asked him to clarify about the password bypass because it's mentioned in his appraisals. I think it was 2009. Can't remember exactly when, but there was development throughout the year, and he explains it actually continues to this day. So that was something that again he was mentioning in his appraisals about his assessment of how he's performing as an employee. But in his evidence to the judge, he suggested that was something that was developed on his own behalf. The further point I've shown your lordship the copyright notices where he was
Not
happy
on
to,
his own behalf.
well,
He
not
accepted that was done for MD5.
yes, but in his evidence to the judge, he appeared to he characterised the password bypass routine as part of
I see.
alongside
Yes.
discussing the core functionality. Certainly, the rest, which was not the what he accepted, was owned by MD5.
Sorry, I was at cross purposes with you. You're quite right. Thank you.
So the further point I was just going to mention, your lordships have seen it, but the copyright notices where he's put his copyright on software which is specifically related to licensing. I don't think there's any. I'm sure my learned friend will tell me if there's a dispute about that, whether that program was related to licensing or not. But on its face, it seemed pretty clear. And then finally, I don't know if your lordships recall the passage earlier where I took your lordships to. It was in the context of discussing Mr. Penhallurick's evidence on the timestamps, but where I took him to the fact that his software was being worked on during working hours, and he gave his evidence that it was all integral to the security aspects were integral to the core program. And so in my submission, taking all that together, it's just improbable that he was sort of working on things at home, yet having in his mind this clear distinction that everything that he did on core functionality was his and done in his own time, and everything that he'd been given permission to do and was working on in work was limited to this security licensing feature. So that's the distinction. The final point to note, although I'm in some difficulties dealing with it in the sense that Mr. Clark's evidence, where he ran through the analysis of what he saw as the functionality in the various versions of the software, and his conclusion on that was that the developments that happened over this period from January onwards were significant, and he said demonstrably more extensive than simply securing the software for customer use. That, for your lordship's note, is Clark 2, Supplementary Bundle, tab 24, page 307, and it's paragraph 37F. Now, I put that statement to Mr. Penhallurick in cross-examination. He disagreed with it, so and he characterised the developments as not being significant. So and not having the benefit of an expert, and I didn't further press that with him. So there was a dispute on exactly the nature of those developments. So I don't think I can really press that particular point further, but just to note it, and it certainly wasn't accepted that all of that development work only relates to licensing functionality. My Lords, I think that the final point that I haven't addressed on the 3rd to 8th works is the 2016 agreement. I don't think I need to spend too much time on this. I think my learned friend acknowledges that there's quite a lot in that document that doesn't appear to make much sense on its face. And I think the high point of his submissions was that it's possible to construe it as a license to VFC software. We say that the judge's construction, perhaps I should just take your lordship to remind you of what the judge said about it, paragraph 106. So it's core page, core tab 8, page 98. And just so you have it, the agreement itself is on the previous page, so you can flick back to it. So he deals with the penultimate paragraph and says that the license itself relates to the methodologies, not software, and he suggests that was a recognition that Mr. Penhallurick's rights might extend more broadly than that. In one sense, my learned friend, I think, points out that it doesn't make much sense if these rights have been published. What are you licensing? And to that, I say that there's quite a bit in this agreement that doesn't make sense when one attempts to apply that sort of verbal analysis to it. For example, the fact that it purports to prohibit disclosure of trademarks and trade names. Among other things, and so in that context, we say the judge's finding was sensible. But I think perhaps the more important point.
What do you say to my suggestion to Mr. Cuddick that clause 1 would make reasonable sense if one understood the word disclosed to mean transferred?
Well, it might make sense, I suppose, if one read it that way. I was just thinking about everything in that clause. Yes, probably trade name, trademarks are probably capable of being transferred. But yes, it doesn't say that, and equally, the judge's construction of the final clause of the agreement ultimately. Difficult to see where it has legal effect, but it makes sense on its face as to what they were trying to do, and I think that's about as high as I can put it, and simply say that the judge's construction was a plausible one. But I think that the point that my lady made to my learned friend yesterday is probably the more telling one, which is. Even if the judge was wrong about his construction of this agreement, well, at most it would indicate that the parties might have formed a different view as to the position regarding the VFC copyright than that which the judge has determined was the case based on his analysis of the evidence. So we say it doesn't really take my learned friend anywhere. So, my lords, that I think brings me to the end of the my learned friend's first ground and to the 2016 agreement.
2008 agreement.
Yes, I apologise, my lords. November 2008 agreement. I won't spend any. I'll try not to spend any time on the principles, but can I just very briefly summarise some of the principles in relation to assignment from the extract that I provided from Coppinger, which is in tab 2 of the Joint Authorities bundle, page 23. and just starting at the bottom, it's 595.
Just so trivial point, I don't think it goes to anything, but do the words contract of service still appear in the section, or have they? It's quite a large section here about contract of service. I can probably find this out for myself, but they're in square brackets in the. If you look at page 10, paragraph 509, words under contract of service or apprenticeship in square brackets.
Yes.
There
Well,
you
I'm
go.
afraid I'm not.
I edit this chapter in Cambridge, so I want to know the answer, but I really don't offhand.
Right.
I'm
I
afraid
just
I'm
don't want to put the wrong section in a judgment. Possibly help it. So footnote 15. The words in brackets are read into 11.2 by reason of the definition of employee in section 178. Right. Like that. Okay. I'll have a look at that. Seems a bit odd. We don't know what the section actually says.
Apologies, my lord, I'm not able to assist at the moment.
Yeah.
Well, between us, we can. So I just want to draw a couple of the principles out here. An assignment doesn't have to be in any special form other than inviting, as specified by the statute, and signed on behalf of the assigner. Moreover, a written signed instrument may constitute an assignment of copyright, even though the word copyright is not used. If on its true construction it was intended, copyright should therefore pass. And then they give examples such as all right entitlement of business or the assets of the business. If copyright form part of the assets and it's apparent from the surrounding circumstances that this is what was intended, in the same way it's not necessary that the words grant or assign be used if an intention to assign copyright can be gathered from the context. And then they go on to discuss it's often difficult to construe whether an agreement is an assignment or simply the grant of a license. But in general, the authors make the point that the whole background may need to be looked at to discover the party's true intention. And so, I just wanted to highlight that as in terms of the general approach, construing the agreement to ascertain what the party's intention was. In that sense, is key, and the author's note, regard may have to be had to the surrounding context. In this case, the context in which the agreement was concluded, in my submission, is absolutely key to what the parties, to understanding what the parties intended, and it's something that the judge had very much in mind. Can I then, on that point, take your lordships to where the judgment dealt with those findings in the context of this agreement? I want to start with paragraph 79 of the judgment, which is in Core Tab 8, page 93.
Why is that evidence admissible? It's a recitation of Mr. Green's subjective intentions.
Well, my lords, I think it's
We are construing a written document. The principles are no different with regard to what evidence is admissible than construing any other written document.
no, but I think, my lords, the background context, the factual matrix in which the agreement was concluded, is important in the sense that that will be information.
To be sure, but we know from the field of contracts, and this is after all a contract, that evidence as to subjective intention is not admissible. That's the exception to the factual matrix. And when it's recited, Mr. Green said he drafted the November 2079 agreement because he was aware, based around the methodology, and ... Mr. Green wanted something formal in place to confirm MD5's rights. That's a recitation of his subjective intentions.
Yes, but I suppose my submission would be that if the facts are such that, as Mr. Green's evidence was, that Mr. Penhallurick had been essentially making noises about his claim to rights, and that was of concern to MD5 and was creating, I think Mr. Green talks about a bad atmosphere in the office, and that is part of the factual matrix in which
it must be the case
then,
that something gave rise to the 2008 agreement. Obviously, it wouldn't have just appeared out of thin air. So, insofar as your submission is that there must have been some, let us say, difference of views between the parties, and that the 2008 agreement was intended to resolve those in a written agreement, then no difficulty arises. But if you're trying to go further than that and say, well, Mr. Green's evidence was that he wanted to confirm MD5's rights, then that's inadmissible, surely.
I understand. I think I understand the distinction your lordship is making, and I'm not submitting that what Mr. Green says he wanted to do with this agreement per se is the way in which your lordship should interpret it. But the point I was stressing was the former, that there was evidence as to the fact that there was a sort of nascent dispute. I mean, Mr. Green just talks about Mr. Penhallurick's complaints about owning some rights, and so that was an extant issue at the time that this agreement was concluded.
Yeah, and so isn't what the judge says at 81 correct? He says it may be that Mr. Penhallurick and Mr. Green approached the agreement with different convictions in mind. Mr. Penhallurick may have become convinced he owned the copyrights. Mr. Green believed the copyrights were MD5, and then one has to look at the words objectively on the assumption that, in fact, at that point in time, they were owned by Mr. Penhallurick.
Yes, I think that's right. And I don't dispute what the judge finds at conclusions in 81. So yes, I think that's right. I just wanted to draw really your lordship's attention to all of the findings that the judge makes here, or the points that he makes about Mr. Green's evidence of the state of play, as it were. But the judge is right to recall that the parties certainly may have had different ideas in mind.
Do you accept that you have to approach interpretation of the agreement on the footing that Mr. Penhallurick owned the copyright? If the background is that both parties approached the November 2008 agreement with different convictions, is it part of the factual matrix that Mr. Penhallurick owned it? And if so, how do you explain that?
Well, I think the distinction I draw there, my lord, is that the premise that the judge is approaching the construction is on the fact, if you like, the legal position as to who owned the copyright.
That is what a reasonable person would be able to determine, given all the facts.
Well, there, I don't. That's not my submission, and my submission is that
if the judge has determined the point and said this is who owns the copyright, then it must follow that a reasonable person would be able to find that out.
Well, presumably what the judge is saying at the end of 81 is it only matters if, but for this agreement, Mr. Penhallurick would own the copyright.
Yes, I think that's...
I understand that, but it's how one gets from that to it being part of the factual matrix that it is so.
Well, I don't...
I think you agree that it does, and I'm just wondering...
I wouldn't accept that it's part of the knowledge that must be attributed to the party, or that a reasonable person has that knowledge.
Would you say, presumably, that the reasonable person is judging what is happening in 2008,
Yes, based
at
on
which point the legal position has not been, in fact, determined.
yes, I think my lady articulates that very well. That would be my position.
Interesting.
So, well, the judge considered the wording of the agreement and its interpretation at 82. My learned friend's taken you to this, and just to go back to what the judge found here, from the objective meaning onwards, the objective meaning of the language of the third paragraph doesn't support the contention that it was granting a license or indeed granting anything. The words of the software developed at MD5 by itself, solid VFC, is the sole property of MD5 Ltd, including the access code, in my view, objectively mean that the VFC software is the property of MD5, and then he goes on to say the software can only be the VFC software. Ownership can sensibly only mean ownership of the copyright in the VFC software. Following paragraphs 83 and 84, dealing with future assignments, I'll come back to that, but then at 85 he finds on that basis that the November agreement, well, he finds that it was a binding agreement, and then that if MD5 had not already been entitled to first ownership by reason of its status as employer, the effect of the November agreement would have been to assign these copyrights to MD5. So those were the judge's findings. We obviously support that conclusion, and it is consistent with a background in which there was an extant dispute as to exactly what the ownership position was, or at least in which Mr. Penhallurick had been making noises to the effect that he didn't, that he had some rights in the copyright. And my learned friend's attack on the finding really comes down to 2 points. He says that language is that of confirming an existing position rather than assigning anything. And he says that construing it as an assignment is surprising because it would appear to be contrary to the intention by the party. I think that's the point that my lord has made. And as the first point, I have to say I don't see why it is. I don't really understand my learned friend's point that simply because an agreement is worded so as to confirm an existing position, that necessarily precludes it from operating as an assignment.
So you say in business people often say confirm when actually it's something being said for the first time.
Indeed. And indeed, I mean, they're often drafted in a very different context to this, but confirmatory assignments are not unusual, where there is perhaps a prior agreement, but it's not entirely clear as to the legal position arising out of that. And so that point alone doesn't dispose of the point that this could be an assignment. And putting that aside, when one looks then at the words of this agreement, the focus of it has been, I think, on the third paragraph in particular. But there's also the paragraph, the short paragraph below that. Sorry, well, I'm actually looking on the page 92 of the judgment, which is convenient. The short paragraph below that, I agree to the above statement and conditions, signed by Mr. Penhallurick and Mr. Green. And looking at in the context of the agreement, above statement can only, in my submission, be a reference to the statement that the VFC software is the sole property of MD5. So that's what Mr. Penhallurick is agreeing to. And in my submission, if, in fact, Mr. Penhallurick retained any legal rights in the software, and by signing a statement agreeing that it's the sole property of MD5, he can't be doing otherwise than transferring whatever sort of residual rights belong to him to MD5. He's confirming that they own it. The absence of any reference to assignments or grants is not determinative, as we've seen. And all of that, my lords, is especially true of what is a rather poorly and not professionally drafted agreement. That's why the context, the factual matrix that I've referred to is particularly important, significant in construing this agreement. And as to the parties' intentions, I'm going to try and steer, and this is my learned friend's point that I'm trying to address, and try and steer away from addressing subjective intentions here. What is clear in my submission from the objective construction of this wording is that the parties intended to arrive at a contractually binding agreement that the VFC software was owned by MD5. Inarguably, in my submission, that is what the words that we just looked at confirm. So, in terms of the parties' intentions objectively construed, if and insofar as Mr. Penhallurick retains some rights, then in my submission it's clear that the only way to construe this agreement consistently with that intention is for it to operate as an assignment of any and all remaining rights to MD5. That would be the way to achieve the same result. So, my lords, that's the point in terms of my learned friend's point on the assignment, whether language is apt to assign per se. That is all, of course, subject to his caveat, which is, well, what does the software developed at MD5 by yourself and sold as VFC actually cover? And this is where my learned friend reprises this notional division of the copyright between the core code and the parts relating to security or licensing that were necessary to sell a product on the open market. And I've addressed your lordships on that notional split. And as I've shown your lordship, the judge concluded at 91, firstly, that it wasn't supported by any contemporary documents, that it was in the parties' minds, and I've taken your lordship's that evidence. And secondly, that no reason was given why there was any commercial logic. And as to that, in my submission, the judge was clearly right to make that finding, especially when it's entirely unclear on the basis of this agreement where that notional boundary between those aspects owned by MD5 and those owned by Mr. Penhallurick would fall.
Yeah, so I think your point is clear, but just putting it in my own words, what you're saying is that when it says the software developed at MD5 Limited by yourself and sold as VFC, what is conspicuously absent, you say, is any reservation of pre-existing software.
Indeed. And always, what is also important, one has to read that rather long clause as a whole. It is the software developed at MD5 by yourself, but sold as VFC. So it is specifically relating to, it's the product that goes out there and goes on sale. That is what ultimately the ownership is being confirmed in. And if one just explores from the commercial logic point of view, the consequences of what my learned friend is proposing, if the copyright was notionally divided in that way, then presumably Mr. Penhallurick, for example, would have been entitled to assign his rights in the core functionality to a third party, while MD5 retained the rights in the security and licensing aspects and whatever they might be, without any definition, of course, in this agreement. Clearly, the VFC software is only a viable product taken as a whole, so one then has a slightly absurd situation where neither of those parties could independently exploit this product, absent some sort of complicated cross-licensing arrangement, referring to who knows what aspects of the software in which their respective rights lay. So, of course, that would be the absolute opposite of commercial logic. And of course, my Lord's point, if that sort of complicated arrangement had been contemplated, one would certainly have expected very clear wording setting out the respective rights. And I think even making allowances for the fact that this wasn't a professionally drafted agreement, in my submission, it's just inconceivable that the agreement would be completely silent on that, if that sort of division was indeed what was intended. So those are my submissions on the division. My learned friend makes a point about software developed at MD5 by yourself and suggests that must relate only to work done either physically at MD5 or I think in the course of employment. I think my answer to that is really the same in terms of the commercial logic. It results in the same split, and one would expect much more clear wording than simply, I mean, essentially he puts a far too great a weight in my submission on the word at.
Completely uncertain, wouldn't it? Because nobody would be able to establish in retrospect where Mr. Penhallurick was at the particular time that he
Indeed.
wrote a particular line of software.
Yes, indeed. That's precisely the point. And I think really the same point applies to access code. I think my learned friend, again, relies on that as sort of consistent with it relating to security features. Or
You rely on the word including.
Indeed, includes the access code. I was going to, I'm not going to take your lordship to the cross-examination, but the judge's findings on Mr. Green's evidence about access code at paragraph 87 essentially were that his evidence, and it was a little confused about exactly what he was talking about.
But again, that's subjective intention.
Yeah.
Whereas
Indeed.
your better point is to say, well, take it at face value. It simply says including the access code.
Indeed. So I don't think I need to.
And therefore it must mean more than the access code.
Yes. and that is the point that the judge makes, and
Yeah.
rightly so. So those are my submissions. I think those are my submissions on the agreement. Oh, the final point is the whether it is capable of operating as an assignment of future rights. And my learned friend takes the point that he says the November agreement isn't supported by consideration. The first thing to stress there is that can't affect whether it can operate as an assignment of the existing rights. And we say that because of that, really, this point doesn't really seem to matter much, because my submission, Mr. Penhallurick, has no credible argument that any VFC software created after this point wasn't done in the course of employment. Apart from anything else, the agreement itself states that he's going to be paid for his continuing contribution to VFC. The payment only be applicable while you're continuing your involvement in development of software. So it doesn't really, if it wasn't capable of operating as an assignment of future rights, it doesn't really take my learned friend anywhere. And secondly, we say there plainly is consideration here, and that is the bonus payments provided for in the first paragraph. And I have to say, I don't really understand the basis of on which my learned friend suggests that the payment of the bonus in the first paragraph is somehow severable from that third paragraph. And I'd stress again that final sentence in which Mr. Penhallurick says, "I agree to the above statement and conditions." So he is agreeing to the whole of it, including the bonus. So, my lords, those are my submissions on my learned friend's second ground of appeal, and that just brings me to the matter raised in my cross appeal as to copyright.
And what's the point?
Well, my lord, I understand the point my learned friend makes. The point really is a short one. That's simply that Mr. Penhallurick, and I understand it from my learned friend's skeleton, but I can give you the references if it's not accepted, accepts that he has in his possession various copies of the VFC software. If the judgment is upheld and that copyright belongs to us, then MD5 is not content for it to remain in Mr. Penhallurick's hands. And if there was a finding of infringement on the basis that...
I don't understand this. because you won at trial, and presumably you would have asked for whatever delivery up order you wanted on the strength of that. Maybe you got a delivery up order, I don't know, but why is that not good enough for you?
Well, my lord, we didn't, and that was because the judge made no finding of infringement. So the judge made a finding that we owned the copyright, but he didn't make a finding that the copyright was infringed, either on the basis that Mr. Penhallurick had admitted that he continued to hold and store software, or indeed on the specific point about the VFC3 source code. So it's just the point that there was no finding of infringement made that would enable us, MD5, to avail itself of that right.
I'm sorry, I'm being very slow. It's my fault. You're quite right. I've got the point now. But can I ask Mr. Cuddick, would there be any opposition to an order for delivery up in the event that the finding of ownership of copyright on the part of MD5 was upheld?
Well, in principle, no. I suppose it depends what the finding was, because you've got the problem, obviously, of the September 06 software. If the finding was there was an assignment of all VFC copyright, then clearly that deals with the issue. If it's simply a finding that the material written by Mr. Penhallurick whilst he was an employee was the copyright, and that was owned by the employer, then it does raise the issue about what was written before and what was written afterwards. But in principle, no, I don't imagine there's a problem with delivering up whatever the. After all, in the course of disclosure, we've given them copies of this software we have, so they know we've got this, and we've maintained it because we're saying it's our copyright.
To be sure, I understand that, but once that issue is resolved.
Yes, absolutely. No,
all right, so it doesn't seem to me that we really need to go into this. Thank you very much.
Those are my submissions.
I've got a sort of number of submissions. They won't, I hope, take very long. Well, there's a continued references in Bernard's friend's submissions to the timestamps being unreliable, and the skewing of the timestamps. As I think Justice Arnold put it, Bernard friend, it's not the case that you can easily skew a date to give it an earlier date. The earlier date is clearly shown as September and or December in different cases. Secondly, Mr. Clark accepts that the last written date is generally accurate. And the various documents which my client has produced as a result of his forensic imaging of his systems, SB1, SB4 and SB22, all give that last written date. So we have it from my friend's own expert that it's likely to be generally accurate. And Mr. Clark, for what it's worth, also says that this is in accordance with his own analysis of the files. So it's hard to see on what basis this suggestion of inaccuracy could be made good. My learned friend then, in the documents handed up this morning, again sought to cast doubt on SB1 in particular and the markings in red. Well, as you'll see in the email from my instructing solicitors, which included this document, and it talks about item 104 being what's added in. And clearly not everything else that's in red has been added in, and that's clear if one looks at the document in supplementary bundle 1.1. So the very top line is what's been added, marked path item 104. So that's the thing which the email specifically says, yes, that's what we've added. The next elements, full path, the file name, date created, date last written, and hash value. My client's evidence, those are all the results of the forensic imaging and investigation of the data. And looking below that, you'll see about halfway down the page, just under the word public, see about dialogue, brackets, then the colon is in red. Actually above that, of course, just by the first hole punch, static character, this file equals is in red, file, and then there's a semicolon there again in red. So the use of red in this does not mean that is something that's been added by my instructing solicitors in the course of litigation, and it doesn't therefore cast doubt on those dates, the date created, the last written, and the hash value dates. In particular, the hash value, of course, is completely consistent with Mr. Clark's own investigations. So the fact that Mr. Clark didn't find them in the files he looked at does not mean to say these were not found by my client when he carried out the investigation that he went through. But it is perhaps worth mentioning at this point, my client was employed by the defendant as a forensic analyst for 10 years. He has an MSc in this subject. He's unlikely not to know how to do this. He's unlikely not to know how to extract data such as the files, the appropriate dates of the files. Well, the next point about that trip of correspondence, as my lords pointed out, that when the last letter was written by my friends instructing solicitors, you're making a point, I want to turn to the actual document. They say we reserve client's right to challenge that information, which simply appears to be written in the PDF document with no apparent explanation. Well, it was dealt with in chief by my client, that's Supplementary Bundle Divider 31, page 473, saying that this was the result of a forensic examination. And it was raised in cross-examination by my learned friend, Supplementary Bundle Divider 33, page 517. And the answer was the timestamp was the result of the forensic imaging. And he wasn't cross-examined any further on the point, and it certainly wasn't suggested to him that these were in any way unreliable. And you've already seen Mr. Clark's evidence, which again doesn't suggest there's anything unreliable in it. My learned friend made the point that I asked you to accept that some but not others of the timestamps are accurate and some and or inaccurate. I'm simply pointing out that the evidence suggests that the September and December dates are likely to be right because they are the last written dates, the date was created, and they were as ascertained by my client in a forensic manner. On any basis, we know that the dates were before the disputed conversation, which we now know was in January 2007. Well, the third point I was going to make was that, read my writing. My old friend is suggested in submissions that there was something strange that in January, after this conversation, Claimant went back to the old September files rather than starting in the December files. And it's hard to see why that is. If the September files were still part of the VFC software in his system, it makes perfect sense that he'd copy the whole of his VFC files from his system onto the defendant's system to carry out the work which is now jointly anticipated they're going to do. Whilst my client couldn't remember exactly what he was doing at that time, it's hardly surprising he's been asked these questions 14 years after the event. We'll just start and put the point to my learned friend that all the discrepancies in the timestamps are unlikely to result in the date being later, and there's nothing to suggest a discrepancy could result in an earlier date. My learned friend launched into an answer accepting that what he's going to say wasn't actually an answer to my lord's point, but he took you immediately to the a passage or something derived from Mr. Clark's third witness statement, and this was that table at paragraph 39, I think, of Mr. Clark's third witness statement. And he pointed to the fact that there were files which were identical from the September files from my client's system. Identical files were found on the defendant's files dated January as opposed to September, but they had identical times of the day at which they had been saved. He suggested that this raised some sort of query. One of the first points I make about this is that what Mr. Clark is looking at, I think it's important to bear in mind, is an analysis of files on the defendant's own system. And the analysis shows dates starting on the 18th of January, which significantly is a day after my client said this meeting took place, the demonstration took place. And my client made that statement about the 17th of January right back in his particulars of claim. So at a time he hadn't even seen these files from the defendant's system. So that's the time scale, the time tie-in there is, in my submission, highly significant. It does suggest there was this conversation in January and not as Mr. Green originally suggested and the judge found in December. It does again suggest that what he demonstrated to them was a software, because that's what the evidence he had actually produced by December. And this, of course, it's common ground that what he put onto there was something from the September 06 files, which again shows that whatever else had happened, the September work had not been abandoned. But I don't think there's any, my learned friend doesn't make any point about the last written date, and he accepts that the last written is, you can have a different last written date simply by saving a file, even if you haven't made a change to it, but the act of saving it will give it a new last written date, but retaining the same hash if you haven't made any changes. So the only point he really can derive from this, other than any points I can find which support my case, is this funny coincidence in the precise times of day on which the last modification took place. The first point about this, it's only the case in 2 out of the many VFC files. Certainly in the case of the first of the entries, the line 4, or row 4, it looks like it's a result of some sort of save all command, because the 3 preceding files also have exactly the same time of saving. It could be simply a coincidence. And it's interesting to note that Mr. Clark, in his report, where all this comes from, doesn't make any comment about this whatsoever. So this is something which has come simply from a learned friend's supposition, not something which any witness has actually suggested is anything to be concerned about. And my learned friend, both in front of yourselves and in front of the judge at first instance, has expressly said he doesn't suggest there is anything untoward or anything dishonest or anything bogus. Well, as in my submission, there's nothing in this document or this point which should lead the court to doubt my client's evidence regarding the September and December documents. It's certainly not a basis on which to discount all of my client's evidence as being too confusing, as the judge did. I mean, it's quite probable, quite understandable, at the end of a truncated IPEC trial with very limited cross-examination, it's quite understandable the judge may be confused by this, but it doesn't mean to say that the actual documents are actually confusing when analysed, because one thing is clear from them, the September 06 date and the December 06 date. Well, just briefly on the appraisals, my learned friend took you to one of the appraisals and mentioned the request. But of course, it doesn't say what the request was for. And as my Lord Justice Arnold pointed out to my learned friend, it could be a request to market, a request to develop it to market. And there's nothing inconsistent with that, or in my submission with any of the other appraisals, with the claimant's case, that having demonstrated the software in December, the parties were very excited by this and they decided jointly to take it to market to their mutual benefit. So my learned friend took you to the case of King. I'll just make a few brief submissions about King. I don't think I need to take you back to it. But also, if you just by looking at paragraphs 19 and 20 of that case, you can see why it's so different to the present case, particularly when you factor in the September 06 material. In King, the very work he was doing was for the purposes of his reporting to his employer. In the present case, it's very different. This is his own personal project. VFC was something my client had come up with. It was his idea. He had developed the manual methodology. He had done his master's on this. He then started writing it back in September 2006, well before any employment was contemplated with the defendant. He then continued writing it at a time when they knew nothing about it or didn't even know he could write software, whereas of course in King they were presumably very well aware that the reports he was writing were, that's what he was handing over to his employer, rather different in the present case. So applying the test which the Court of Appeal in the King case put, what was the causans of the work in that case, one could see it was his employment. In the present case, there is nothing to suggest this project was, his employment was a causans of this work. My learned friend then took you to the issue of the discussions. Just so it's clear on this, it is common ground that the methodology was shown pretty much straight after my client joined, and it was used by him and various other employees, although my client said they weren't terribly keen on it or weren't very good at applying it. It's now, or appears to be now, common ground that there was then some other demonstration to Mr. Green in January. That now seems to be conceded. So the question for the court then is, what was being demonstrated? Was it just methodology, as my learned friend and his witnesses say, or was it the software which had been created in the preceding few weeks, as my client says? Well, the first point on that is, why would one wait 3 months to demonstrate again the methodology that you've demonstrated it back in November and which you and the other employees have been using? Why would you wait 3 months to demonstrate it again? It's much more likely that what was demonstrated in January was a software which we've seen had just been written, just been completed in December, the very software which the defendant's own expert admits was proof of concept, proof, in effect, a working system. It may not have all the bells and whistles, it may have a few glitches, but it was a working system. Surely that's much more likely to be what was demonstrated. And then once that's been demonstrated, the conversation does not go along with saying, well, will you program it for us? It is much more likely, as my client says, well, would you help us bring this to market? And my client says, for mutual benefit. Well, the next point I'd make is that my learned friend made the point that my client and presumably his too were unlikely to have any clear distinction between core software and security or licensing software in their minds. But it's not really the claimant's mindset that's a question here. It's a matter of what is the objective fact, what was actually being written in the course of employment. And of course, the first of it, the core software, was something my client has cited before. Is the same old submissions. It was a subject of his master's. It was his own idea. It's a very different thing objectively to work he then does in the course of employment in order to bring that to market for the benefit of them both. And a factor playing into that multifactorial analysis is the fact that when he did work subsequently on the core software, his evidence is he did that largely at home. And yet when he worked on security and licensing, he did that largely at work. So that's a factor which objectively the court needs to take into account. Say, well, yes, that's why there was a distinction between the two. One is done in the course of employment and the other is not. My Lord just sort of pointed out that in the, I'm turning to the agreement now, the 2016 agreement, that it makes more sense if the word disclosed is changed into transferred.
Well, I would interpreted as transferred.
Yes. Purpose. If one interprets it as transferred, then in my submission that supports, if objectively that's what some would read it as being, that would support my argument that what is going on here is a license agreement. Because my client will not transfer it to anyone else, he's granting a license to these people to carry on marketing it for the mutual benefit. Well, that's all I would say about the first ground of appeal. Very briefly on the second ground of appeal. My other friend referred to the assignment, as he puts it, being of the VOC software as a sole property of MD5. but that isn't what the assignment says. The assignment firstly uses the word confirm, and secondly uses the phrase software developed at MD5. Now, that is what, those two words put together are what shows, I say objectively, that this cannot be an assignment, because the software developed at MD5 is applying a legal test. It's in answer to my Lord Justice Sir Christopher Floyd's point that no one would be able to establish in retrospect what this is. Well, that is the legal test. Section 11 requires a fact-finding person to say what was done in the course of employment. So all this assignment is doing is picking up in exactly the same word as Section 11 would require one to do in any event. Now, it may not be easy for the man on your Claimant omnibus as a reasonable observer, but still, as an objective thing, the court can go through that and say, well, what was, objectively, what was the work that he had done at MD5? What was the software he developed at MD5? And that software, I confirm, is owned by MD5.
So you're saying at MD5 means in the course of his employment at MD5, not physically located at MD5.
No, absolutely right. It's in effect picking up on the test from Section 11, which is, as I would say, objectively, perfectly, not easily, but it's possible to assess what that is by the same process which this case is all about. So, and if you're confirming something, what you do is confirming that, yes, I confirm that stuff I did in the course of employment, you own. And that makes perfect sense. And you then look at the agreement objectively, just a rational basis. Why?
Well, just on that, what do you say to Mr. Conway's point that we're familiar with the concept of a confirmatory assignment, whereby parties enter into an assignment explicitly to confirm what is probably already the case, but to put it beyond doubt?
Well, I say I wouldn't object to this being construed as an assignment of the work he had done in the course of employment, but of course that's confirming something which already is the case, which is because it's theirs because it's in the course of employment. So it's just confirming that. So insofar as you need an assignment, here's the assignment. I mean, so that gives a certainty, hence the word confirm.
Yes, but then one needs to be clear as to what your case is, because what you are doing is distinguishing between two possibilities. One is it's not an assignment at all. The other is it is an assignment, but it's a limited assignment. And of course, I appreciate perfectly well, those are two possibilities which one can contemplate. But when you were opening your appeal on this ground, I had understood it to be your case that this was not an assignment at all.
Well, yes, I think that would be my starting point. One should not read it as an assignment at all. It's simply confirming something. Insofar as it could be read as an assignment, the words make it clear that what's been assigned is simply software written at MD5. Now, objectively construing it, I would submit the factors do point all that way. That the first point I'd make is that why would, well, the first point is actually, if it was going to be all the rights in VFC, why not say that? That's much easier than saying all the stuff you've done here, including the access code. You simply say all of the VFC software that is solved. You wouldn't have the words written and developed at MD5 in there at all. The second point I'd make is why would you be confirming the assignment actually in a way to actually assign it for no payment? Because this agreement does not have any payment, because the provision for a bonus is only payable whilst C remains an employee and remains continuing support for the VFC software. So objectively looking at this, Mr. Penhallurick is giving up his rights in his software in effect for nothing. He gets a bonus payment whilst he remains an employee and whilst he does work, continuing to provide support. So he's getting nothing for this assignment. So that would suggest, again, it shouldn't be read as an assignment of all the rights. It should be just simply confirming something for the, to clarify, if you like, or make Mr. Green's mind easy. But the final point I make is the point about including the access codes. Well, I take the point the word include is inclusive. It shouldn't cut down the previous word. But of course, access code wasn't the only aspect of the software which we accept was written for the benefit of the defendant. There's the security and the licensing materials. So those are all factors which we accept were written for the defendant. So there is meaning to that. And it's much easier to read it like that than to think, why is it that the draftsman of this contract chose fit to refer to access code, but not the source code, which is really what this is all about? It's a very bizarre construction. So, well, actually, you mentioned the minor point, but you completely omit the major point.
Sorry, are you submitting that access code should be interpreted as meaning source code?
No, that's the other way around. That's my learned friend's case. His client, Mr. Green.
Well, exactly. So what is the point you're making here?
Well, the point I'm making is that if it had been intended to cover source code, that's what it would have said. The fact it just chooses to refer to access code shows that actually it's not intended to cover source code.
You would say on that, of course, I assume that the judge went wrong because he refers to Mr. Green's explanation, which was subjective.
Well, yes. Can I just take brief instructions? My instructions from the client is that the access software is the specific dongle company codes. I'm not sure I can entirely follow the point, but maybe this would be more apparent to my knowledge. So this is saying the access code referred to as a specific dongle company.
Yeah, the key lock module. Yeah, I understand.
Which
you say there was more.
Yeah,
and hence the
you'll
word
see that
including.
referred to in the actual comparison source codes. And also, those my submissions, so I can assist you any further.
No, thank you very much. That's very succinct. Well, thank you both for your submissions. You've given us a lot to think about, and we will therefore reserve our judgments and give it proper consideration. In due course, you will receive a judgment, first of all in draft in the usual way, and I'm sure you both know this perfectly well, but just to remind you, the purpose of that exercise is to allow you to correct typos, wrong dates, other obvious errors, but not to re-argue the case. Once that has been done, the judgment will be formally handed down, and almost certainly by a remote mechanism, but even if it's handed down in court, no attendance will be required. Once you have received the draft, please attempt to agree an order to give effect to whatever our decision is. If you are unable to agree an order, please lodge brief written submissions on any points that are in dispute. Thank you.